Okay, looks like we're ready to start. This is Public Service Commission Docket 175701 in the matter of the application of Questar Gas Company for approval of the Vermillion acquisition as a Wexpro 2 property. Why don't we start with appearances for the utility?
Thank you. Jennifer Nelson-Clark. I'm an attorney for the applicant, and I have with me Barry McKay, who is the Director of Customer Rates and Regulation for Questar Gas, and Brady Rasmussen, the Vice President and General Manager of Wexpro Company.
Thank you.
Good morning. Patricia E. Schmid with the Attorney General's Office representing the Division of Public Utilities. With me this morning as the division's witness is Douglas W. Wheelwright. D. Wheelwright.
That's an important clarification. Thank you.
It is.
And my name is Stephen W. Snar. I'm counsel for the Office of Consumer Services. With me today is Gavin Mangelson, who's a utility analyst.
Okay, thank you. Any preliminary matters before we go to Ms. Clark?
Yes, we have a couple of housekeeping issues. The first deals with confidential information. The vast majority of Mr. McKay's summary that he will offer today is not confidential. However, there is a piece that sort of fits in the middle that we'll need to treat as confidential information. So for purposes of your record and also for if we're streaming, I wanted to note that in advance. And then the second matter that I wanted to raise was the issue of cross-examination. Counsel has spoken, and if it's appropriate and if you feel comfortable, we're happy to do all of the summaries at the same time and then perhaps have questioning via the panel. We recognize that Mr. McKay will be our only testifying witness today. We've brought Mr. Rasmussen with us in anticipation of some questions. And so Mr. McKay may be in a position to want to send some his way.
Sure.
So if that works with the commission, we think that would be an appropriate way to proceed.
And if there's no objection from any other party, and it sounds like there's not any to handling any potential cross-examination that way, that makes sense. With respect to the first issue, I think the way we'll need to handle that is if at the appropriate moment, if you want to make a motion to close the proceeding to the public, then there's a required finding. The commission has to find that it's in the public interest to do so. So we can deal with that at the appropriate time, and then we'll make sure that the only appropriate people are in the room and the streaming is discontinued for that
Perfect.
portion.
That raises one other question in my mind, and it is possible, I guess, during cross-examination and examination by the commission that they may also raise issues that are confidential, and so if I interject, I will apologize for the rudeness in advance, but we'll be watching.
If anyone asks a question that you think would require any confidential information to ask, please jump in and stop us before we keep going.
Thank you. Okay.
Thanks. Any other preliminary matters? Okay, then, well, Ms. Clark.
The company calls Mr. Barry L. McKay.
Oh, yeah, you're going to stay there. Mr. McKay, do you swear to tell the truth?
Yes.
Thank you.
Mr. McKay, will you state your name and business address for the record?
Barry L. McKay. And I think I'm at 333 South State, Salt Lake City, Utah.
And are you the same Barry McKay that pre-filed direct testimony in this matter along with accompanying exhibits 2.1, 2.2, and also a supplemental exhibit 2.2.1S?
Yes.
Did you actively participate in this docket and in the development of the settlement stipulation that is before the commission today?
I did.
Can you please summarize that settlement stipulation?
I can. Turning to the stipulation, I want to at least touch these first few paragraphs. I don't need to go through them in detail, but I do want to recognize what's included in them. And actually, the first paragraph in the stipulation is simply recognizing that both this commission and the Wyoming Commission needs to approve these properties, or shall we say at least this stipulation, before it will become effective. The first numbered paragraph is a reference back to Wexpro 1. The second one is a reference back to Wexpro 2. The third paragraph is a reference to the trail unit settlement stipulation, and then fourth paragraph is referencing the Canyon Creek settlement stipulation, all of which govern how we go about having these properties approved before the commission and then develop them, and the criteria that must be reached in order for them to continue to be part of that. We then recognize that within the Wexpro 2 agreement, there's two specific parts in paragraph 5 that we were relying on and that required us to come before both the Utah Commission and the Wyoming Commission. One paragraph identifies that there's certain properties that we shall bring before the commission, and we have about 3 of those. We'll point those out in a minute. And then for the first time, before any of the commissions, Questar Gas and Wexpro has brought a couple of properties where it was our choice to do that. Then we simply summarize in paragraph 6 the timing of the acquisition of the Kenny unit, which was in April of 2015. Paragraph 7, identify the trail, the Whiskey Canyon, and the Canyon Creek units and their purchase, which was in December of 2015. Then we did make the filing before this commission the beginning of this year, January 9th. And we point out in this paragraph that it was the trail, the Kenny unit, and the Canyon Creek override that fell into the category of that we shall, or that we must bring that before the commission. All of those properties were in the development drilling area. And then the Whiskey Canyon and the Canyon Creek outside the PA, that stands for outside the participating area, were properties that was a choice or that we may bring them. And we identify that in that paragraph. We properly filed, including all of the information that was thought of as we had the process of approving the Wexpro 2 agreement. The hydrocarbon monitor performed his responsibilities in reviewing all of that and filing his initial report within the 7 days of our filing of our application. We obviously had scheduling conferences. We held 2 technical conferences within the 2 dockets. The one that's of importance here would be the February 2nd one that we held in Utah, answering numerous data requests, the filing of direct testimony. And then in paragraph 14, the parties met for the first time on the 23rd of February, along with the hydrocarbon monitor. And I want to point that out. As you'll see here in a minute, we needed to rely on his expertise and actually his third-party verification for a settled-upon change of how Wexpro will be developing one of the properties. And he helped in that process. And then simply in 16 is the recognition that this resolves all the issues in the docket before this commission. So key things are the terms and conditions, which begin in paragraph 17, where it's identified that the trail unit and the Whiskey Canyon unit shall be approved as Wexpro 2 properties. In paragraph 18, we identify that the Canyon Creek property, which includes the outside the participating area as well as the overriding royalties, will be approved as a Wexpro 2 property, subject to a change in the way that Wexpro will develop the properties. And they will replace what was originally anticipated as a horizontal well with a vertical drilling program in the area outside the participating area. And after those first 3 wells are drilled, Wexpro has agreed that they will bring the results, the costs, the volumes that are anticipated before the parties, and will not proceed with further drilling until that has happened, as well as the opportunity for the hydrocarbon monitor to review the results of those first 3 wells and deem it reasonable in moving forward. And then as we worked through this, we wanted to make sure that everybody realized that we're agreeing to this approach, but we also recognizing that overarching the development of the Canyon Creek unit are still the criteria of the issues that were settled in the trail stipulation as well as the Canyon Creek, which is the limiting amount of volumes that Wexpro can provide to Questar Gas, as well as needing to meet the 5-year forward curve before they drill and meeting the commerciality test. So we make a reference to that at the end of that paragraph. And I think now, to provide further clarity and to get some additional evidence on the record, we've prepared a few, I guess we call them hearing exhibits, but those are going to be confidential.
They are, and if I can approach, I'll give you copies and we can just briefly make the motion and lay the reasoning for both.
Okay, so you'll provide us with 3 copies prior to the motion
Yeah, exactly.
and to the 2 parties. Okay, thank you.
The parties will have them.
They already have them. Okay, thank you.
Now that we have them in front of us, the company would move that the hearing be closed for the portion of Mr. McKay's testimony when he testifies to these 4 exhibits you have in front of you. And if we can briefly flip through them, I would preface it by saying these are either updates or supplements to exhibits that have been previously filed as confidential exhibits. You'll note that the first one has some information related to drilling and costs that the company deems confidential. The second is supplemental to Application Exhibit B. It also contains future drilling plans, which the company deems confidential. The third that you can see has to do with total gas supply, and the right-hand side of that exhibit contains some forecasts. And again, the company deems those forecast information to be confidential. And finally, confidential hearing Exhibit 4 is the future drilling plan, Wexpro's future drilling plan for these properties, and the company deems that confidential as well. The company would argue that disclosure of this information would put it at a competitive disadvantage for negotiations in the future, and it would also cause the company to disclose information that it deems proprietary.
Thank you. Is there any objection to this motion? Ms. Schmidt?
No objection.
Mr. Snar?
No objection.
Okay. We find that it is in the interest of the public to grant the motion and to close the hearing to anyone who's not a party at, until we complete discussion of the confidential information. So we will discontinue streaming at this point. Is there anyone in the room? I'm not, I don't know the names of everyone in the room, but if everyone at the table is comfortable with those in the room, then we can proceed.
It's fine.
Okay. We'll start the streaming again. Thank you.
The company would now move.
Are we streaming? Okay, thank you.
The company would now move for the admission of confidential hearing exhibits 1, 2, 3, and 4.
Any objection to that motion, Ms. Schmid? No objection. Mr. Snar? Okay, the motion's granted.
Thank you. Please proceed, Mr. McKay.
That gets us to paragraph 19, and in paragraph 19, the parties agreed that the Kenny unit at this time would be withdrawn for consideration before this commission. And then we would give Wexpro the opportunity to be able to prove that this unit can be economically developed. If they can, and based on verification, recognizing that the Wexpro agreement is self-governing here, and we know the hydrocarbon monitor would be reviewing their work in that area, and we're assuming that it can be economically developed, then we, Questar Gas, Wexpro, shall bring this property back before the commission. We're not committing the commission or any of the parties that it has to become part of Wexpro 1, but we're simply giving the parties a free option, if you will, on this. And our concern is that the way the Wexpro 2 agreement, I think, contemplated properties being brought before the commission is that you would bring a property and it would either be included or not included, and then that's the way we would live going forward. We didn't want that decision to have to be made on this, as the property looks promising, but there wasn't enough evidence at this time, and we agreed that we would delay that official decision before this commission by us withdrawing that, and then assuming that it's a good property, and parties don't want us, if it doesn't prove to be a good property, to have us, quote, waste our time with having to see that the numbers aren't good. We recognize the hydrocarbon monitor and the review of that process will be able to satisfy that concern. But if it can be economically developed, Wexpro and Questar Gas will bring it back before the commission and give them an option, give the parties an option to have it become Wexpro 2 property. And that leads us to paragraph 20, which they're in the process of discovery and negotiations. There were concerns related to at least 3 areas, and we wanted to memorialize those and agree that after assuming approval of this settlement stipulation in both Utah and Wyoming, that the parties would meet within 45 days and discuss the mitigation of risks associated with other participating areas. Right now, our discussion has been that it's not imminent, but we wanted to make sure we all had an understanding of what that might be out there and provide the evidence to make sure everyone had understanding with it. We also wanted to evaluate the, talk about and discuss the evaluating and the implementing a future sale or retirement exchange of Wexpro 1 assets as their useful life comes to an end. And then specifically talk about the timing. I think it's a little odd. We will freely admit that the time that happened between Wexpro acquiring these properties and then bringing them before the commission has some unique circumstances, but we wanted to discuss that timing, which has not been specifically addressed. And then the last paragraph in the terms and conditions is 21 and is essentially a paragraph that has existed in our other stipulations that recognizes that Wexpro, the paragraphs in the settlement stipulation of Wexpro 1 are still in force as it relates to the regulation, or shall we say not regulation of Questar, sorry, of Wexpro. So I'm going to make one more attempt on that. This paragraph refers to Wexpro and how they are not considered a regulated entity, and that's spelled out in the Wexpro 1 agreement. The rest of this is the general terms and conditions, stating that we feel that this is a just and reasonable resolution of the issues. It's in the public interest. In paragraph 22, it's not doesn't set any precedent as far as other issues bringing before the commission in the future. We'll be happy to provide witnesses, and I think you're seeing that happen today. And then if, in fact, it were not approved by the commissions, how the parties would respond and act. But in summary, we feel this is an excellent resolution of the issues in this case and is just and reasonable and ought to be approved by this commission.
that conclude your summary?
Yes.
Before the company surrenders the floor, it would move for the admission pursuant to paragraph 24 of the stipulation of those exhibits referenced in Questar Gas Company's exhibit index. The parties in the court reporter have been provided with the index, and you will find it if you just open the cover of the binder in front of you. It includes the exhibits, the application and the exhibits that accompanied it, exhibits A through P, including subparts. It also includes the supplemental information that was filed in this docket. The direct testimony of Mr. McKay with accompanying exhibits 2.1, 2.2, and 2.2.1S. And then also the direct testimony of Brady B. Rasmussen, which is exhibit 3, with accompanying exhibits Questar Gas exhibit 3.1, 3.2, 3.2.1S, 3.3, 3.4, 3.5, 3.6, 3.7. And we'll just say with the subparts of 3.7, those were filed with the supplemental information, and 3.8.
Okay, thank you. Ms. Schmidt, any objection to that motion? No objection. Thank you. Mr. Snar? Okay, the motion's granted. Thank you.
Thank you. The company does not have any other witnesses to offer at this time.
Okay, with the understanding that there might be questions later, we will move on to Ms. Schmidt.
Thank you.
Thank you. The division's witness this morning is Mr. Douglas D. Wheelwright. Could he please be sworn?
Sure. Mr. Wheelwright, do you swear to tell the truth?
Yes.
Thank you.
Mr. Wheelwright, could you please tell us by whom you are employed, your position, and your business address?
Yes, I'm a technical consultant with the Division of Public Utilities. My address is 160 East, 300 South.
On behalf of the division, have you participated in this docket?
Yes, I have.
Did that participation include preparing and causing to be filed DPU exhibit number 1.0 direct, along with DPU exhibit number 1.01 direct, 1.02, which were confidential, 1.01, 1.02 redacted, and then DPU number 1.0 direct, your corrected pre-filed direct testimony, along with redacted exhibits 1.01 and 1.02.
Yes.
Why was corrected pre-filed direct testimony filed?
The only correction to the original filing was a change in our summary, and we removed some of the redacted portion of that summary.
The division would like to move to admit the exhibits previously identified. You also have been provided with an exhibit list.
Mr. Snar, any objection to that motion? Ms. Clark?
No objection.
Motion's granted. Thank you.
Thank you. Mr. Wheelwright, did you participate in the settlement meetings?
Yes, I did.
Do you have summary statements to provide?
Yes, I do.
Please proceed.
Thank you, Commissioners. The objective of the Wexpro II agreement was to create a structure and a mechanism that could potentially allow additional properties to be included in future cost of service gas production. The Vermillion application before you today represents the third time that additional properties have been presented for approval. The original application in this docket represented the purchase of varying ownership interests in 4 separate properties identified as the Vermillion acquisition. In direct testimony, the division recommended approval of the additional interest in the Trail property and approval of the Whiskey Canyon property. The division expressed concern with the original proposal for wells in Canyon Creek and concerns with the cost of service from the Kinney field. In response, the company prepared a modification to the proposed drilling in Canyon Creek and prepared a revised cost of service calculation that excluded the additional ownership in the Kinney property. These 2 modifications to the original application are the basis for the settlement stipulation, which has been signed by all the interested parties and has been outlined today by Mr. McKay. The calculations and the assumptions used in the original application and the assumptions used in the settlement stipulation have been reviewed and evaluated by Mr. David Evans, the independent hydrocarbon monitor. The first confidential report from the hydrocarbon monitor was filed with the Commission on January 19th, and the second report was filed on February 27th. In both reports, Mr. Evans indicated that in his opinion, the reserves and associated economic information represented by Wexpro were reasonable. The specifics of the cost of service price projections from this acquisition are confidential, but have been included in Exhibits L1 through L5 of the original filing and in subsequent updates. A comparison of the cost of service price from the Vermillion properties along with the total cost of service price for all of the Wexpro production and the projected market price was included in my direct testimony. The revised projections of Exhibit L5 with the modified drilling in Canyon Creek and excluding the Kinney property show a slight decrease in the total cost of service price for the 3 remaining Vermillion properties. It should be noted that the total volume of natural gas production from the Vermillion acquisition represents a small percentage of the total Wexpro production and will have a minor impact on the total price of cost of service gas produced by Wexpro. The division has reviewed the company's application and subsequent updates and has participated in the settlement negotiations. Key provisions of this stipulation will allow the company to resubmit the Kinney property in the future and require further discussions with the company to clarify procedures for property sale or exchange and potential expansion of a participation area. It is the division's recommendation that the Commission approve the properties identified in the Vermillion settlement stipulation and that these properties be included under the Wexpro II agreement. Approval of the Vermillion acquisition as a Wexpro II property represents the purchase of a long-term resource that could be advantageous to ratepayers for many years. The division believes the terms of the stipulation agreement, taken as a whole, are just and reasonable and are in the public interest. That concludes my summary.
Thank you.
Okay, and that concludes your presentation?
That concludes the division's presentation.
Okay, thank you. Mr. Snar?
Thank you. Hearing today supported the Office of Consumer Services,
Thank you. Mr. Mangelson, do you swear to tell the truth? Thank you.
What is your name, business address? Excuse me. Mr. Mangelson, what is your name, business address, and by whom are you employed?
My name is Gavin Mangelson. My business address is 160 East, 300 South, Salt Lake City, Utah, and I am a utility analyst for the Office of Consumer Services.
Did you submit pre-filed direct testimony in this docket?
Yes, on February 21st, 2017, I submitted 10 pages of confidential direct testimony.
And Mr. Snar, I'm sorry to interrupt. I think you're not picking up on our streaming. If you could maybe move the microphone a little closer to you.
Certainly.
Thank you.
How is that testimony identified in the proceeding here today?
As OCS 1D.
And are there any corrections or modifications to that testimony as you present that today?
No.
We would move to have Mr. Mangelson's previously filed testimony to be admitted as part of the record.
Thank you. Ms. Schmid, do you have any objection to that?
No objection?
Thank you. Ms. Clark?
No, no objection.
Okay, thank you. The motion's granted.
Mr. Mangelson, did you participate in the settlement discussions related to the issues raised in this docket?
Yes, I participated in the development of the Vermillion settlement stipulation, which has been submitted to this commission. The Office of Consumer Services is a party to that settlement agreement.
Have you prepared a statement or summary of the office's position?
Yes, I have.
Could you please provide that?
Thank you. Good morning, Mr. Chairman, Commissioners. The Office of Consumer Services conducted a detailed analysis of the proposal to include new properties within the Wexpro II agreement. In accordance with our statutory mandate, we approached our analysis from the perspective of residential and small commercial customers, who together represent a substantial portion of the customers receiving cost of service gas under the Wexpro agreements. The office's direct testimony identified cost information for cost of service gas from each of the 4 properties individually, and further divided those properties by existing proven developed producing, or PDP wells, and future development wells. We included comparisons of this cost information to current market rates. In addition to the cost analysis of the proposed properties, the office's direct testimony identified other issues that are important to consider in this and any future applications to include properties under the Wexpro II agreement. These additional issues can be summarized into three main points. First, although a combination of existing wells and new development wells may result in a combined cost of service that is below market prices, acceptance of these wells into the agreement means that ratepayers will be required to purchase the additional volumes that come from these existing wells, even though their prices may be at times above market prices. Second, the cap on the level of Wexpro gas as a percentage of total gas supply established in the Canyon Creek stipulation is a ceiling and should not be treated as a target for levels of Wexpro gas. And third, declining volumes of Wexpro gas should be replaced only if the additional volumes can be justified based on their independent advantage when compared to market prices. The office believes that the Vermillion settlement stipulation filed on March 2, 2017 in this docket reasonably satisfies the issues and concerns that we identified. Cost information was used as the principal basis for our recommendations for each individual property, and cost information was the principal factor in developing the terms of the settlement stipulation. Regarding the Whiskey Canyon and Trail properties, the combined cost of service gas produced from PDP and development wells from these properties is expected to be below current market rates. Therefore, the office supports the inclusion of these properties into the Wexpro II agreement as stated in paragraph 17 of the stipulation. Regarding the Canyon Creek property, I will note that the Canyon Creek property refers both to the overriding royalty interest of certain wells within the participating area, as well as to additional property outside of the current Canyon Creek participating area. The office originally opposed inclusion of the Canyon Creek property into the Wexpro II agreement based on the uncertainty of resulting actual prices. During the settlement talks, Wexpro agreed to make certain modifications to the anticipated drilling plan for this property. The changes to the drilling plan are explained in paragraph 18 and initially provide for 3 vertical wells in lieu of the horizontal well described in the application. The revisions to Wexpro's drilling plan for this property should present less risk, result in lower cost of service gas from the new wells, and thereby lower the price of cost of service from the property as a whole. Based on the conditions described in paragraph 18, the office supports inclusion of the Canyon Creek property into the Wexpro II agreement. Regarding the additional interest in the Kinning property, cost of service gas from the existing wells is currently above market prices, and information about the single development well provided in the application does not produce a resulting cost of service gas price below current market rates. Parties believe that further exploration in that field may prove additional well sites that would result in a lower overall cost of service price from that area. Therefore, paragraph 19 provides for the withdrawal from consideration of the Kinney property at this time, along with a mechanism for the property to be brought before the Commission under the cost circumstances described in that paragraph. In conclusion, the office submits that the Vermillion settlement stipulation to Questar's request for the inclusion of additional properties under the Wexpro II agreement will result in just and reasonable rates and is in the public interest, and recommends that the Commission approve the settlement stipulation.
That would conclude the office's presentation.
Thank you. Ms. Clark, do you have any questions for any of the witnesses?
I do not, thank you.
Okay, thank you. Ms. Schmid?
No questions?
Okay, thank you. Mr. Snar?
No questions.
Commissioner White?
Just with respect to the Kinney property, to the extent it's not confidential, what is the anticipated timing of the additional exploration of potential request for inclusion?
I think the company would deem the answer to that question confidential, and I think Mr. Rasmussen is probably best equipped to answer it, and he needs to be sworn.
Okay. Mr. Rasmussen, do you swear to tell the truth? Okay, and then is there any objection, Ms. Schmidt, from closing the hearing to hear the answer to this question?
No objection.
Okay, Mr. Snar?
No objection.
Okay, we find that it is in the public interest to close this hearing to the public to receive an answer to this question, so will you let me know if the streaming has stopped? Should we stay closed while you ask?
If we're closed now,
Let's
I
just stay that way.
recommend we stay closed. But
Yeah, let's just discontinue the streaming and stay in Thank you. And I don't have any further questions. Did you have anything else? Clark? Okay. Any final matters before we adjourn?
Yes.
Clark?
Yes, thank you, Commissioner. Two matters. One is that the company recognizes that we will be before the Wyoming Commission on the 17th of this month. I believe that's next Friday. We would request, recognizing that it would be helpful to have a decision from this commission prior to that hearing, we would request a bench order. We recognize that's a lot to ask, and if you all are not prepared to do so, we would simply request that we get some indication prior to the Wyoming hearing. The other matter would be the application did not identify an effective date. We'd like to treat this matter the same way we have treated prior Wexpro 2 matters and seek an effective date of the first of the same month in which the hearings were held. So in this case, it would be March 1st. And I think that is all the company has to add.
Let me ask for one clarification then. With if our commission were to grant a bench ruling today with an effective date of March 1st, and then subsequently issue a written order confirming that, and if the Wyoming Commission were to do a bench ruling with a subsequent written order, just looking at paragraph 20, when the 45 days, and that's not based on effective date, but it's based on commission approval, was it anticipated that that would run beginning with the with the second bench ruling or with the final written order?
I think as a technical matter, it is intended to run with the final ruling that makes all of this effective. That said, I can tell you and assure you that the company and the parties have already been talking. The company is conducting analysis, and we will be prompt about that.
So when you say final ruling, final written ruling?
I think it would be the final bench ruling. If
The
we
final
were to
bench
get,
ruling.
for example, a bench ruling from Wyoming on the 17th, we would deem the clock to begin running that day.
Okay. Any difference of opinion, Ms. Schmidt?
The division would support the issuance of a bench order.
Okay, thank you. Mr. Snar? Okay. Do you have any position on a bench ruling today? Okay, thank you. Any questions from Commissioner Clark, Commissioner White on the motion for bench ruling?
Just to clarify, is there any opposition to the effective date moving to the first of the month? Does that change the position of the office or the division?
Okay. Anything? Why don't we then take a brief, probably about five-minute or so recess. If we need longer than that, we will send somebody in the room to let you know that we might need a little longer. Thank you. We find that the settlement stipulation presented in this docket is just and reasonable and in the public interest, and we conclude that it is consistent with the relevant statutes and the previous agreements in previous Wexpro matters. We approve the settlement stipulation with one change, and please let me know if I have this change correct. On the first page of the settlement stipulation where it says, near the bottom of page 1, this settlement stipulation shall be effective upon the entry of a final order of approval by both commissions. I think we're changing that sentence to say it will be effective March 1st, 2017, contingent on approval by those two commissions. Please indicate to me if that change is consistent with everybody's understanding.
Thank you.
Ms.
Consistent with the division's understanding.
Mr. Snar? Okay. With that change, we approve the settlement stipulation, and we will, subsequent to this hearing, issue a written order confirming that bench ruling. Any other matters before we adjourn?
No, thank you.
Thank you. We're adjourned.
Thank you.